So if, for instance, I was an English husband and I'm thinking about a divorce or a separation, and I came to see you, Steve, as my lawyer, and I say to you, Steve, tell me about collaborative law. What's in it for me? How would you go about responding to that?
Great question. I think what I would try to do is not avoid the question, but first try to understand a little bit more about what you're facing. Where are you coming from? I wouldn't want to just immediately answer the question without a context.
Okay.
So that's my first response. My second response is once I have some sense of the context in which the question is asked, I'd probably say that collaborative law arose in the United States about 15 years ago. A fellow named Stu Webb, who was a traditional family litigator, realized that the traditional adversarial system really wasn't serving clients very well in family law. Yeah. Battling it out in court really wasn't in the best interest of families and children. And he decided to try something different, which was to have lawyers and their clients sit down together with an agreement that they will not go to court and simply try to talk their way into some kind of a resolution that worked for everybody. Okay. So basically a negotiation. So it's a negotiation model. And it proved to be quite effective. Many people were relieved to not have to be battling, but actually working together collaboratively in order to come up with a solution that worked for everyone. And unless it worked well for everybody, people weren't going to sign on the dotted line at the end of the day. After about 5 years or so of doing this, Stu realized that there were a lot of cases that were so emotionally fraught and difficult that it was helpful and desirable to bring in a mental health professional or two in order to help deal with those problems, because lawyers aren't trained to do so. So now in the United States, collaborative law is practiced primarily as an interdisciplinary practice, meaning that there's either one neutral mental health professional who is helping the parties with the emotional aspects of the dispute, or each one has their own family consultant. And the lawyers and the family consultants work together, hopefully in a seamless way, to have a difficult but necessary conversation about what really is at stake, what really matters, what's in the way of the parties actually reaching an agreement. Are there hidden issues, resentments, feelings of betrayal? And people are going through one of the most difficult and painful events in their lives, and it's often difficult to sort through all of those feelings and get to a meaningful conversation about how we're going to divide up our marital property, or how we're going to come up with a meaningful parenting plan for the children when there's feelings of resentment and anger and betrayal and so forth, not to mention sadness. So in recognizing that these emotional issues play such a vitally important role in these kinds of disputes, collaborative law now offers the possibility of bringing in these mental health professionals, if desired, so that the parties can really address all of the issues that are at stake, address all of their interests, not just their legal and financial interests, but their emotional interests as well, and those of their children. So collaborative provides that possibility, but it also, very importantly, it keeps people out of court. It helps keep the costs down, very expensive to litigate, and it empowers the clients because they're making the decision. It's going to be their agreement, not the person in the black robe.